Imagine for a moment that you are in pain. Not just a little ache, but real terrifying pain.
Something serious.
Right, something is very wrong. You rush to the nearest big medical center, let's say it's a prestigious university hospital. You get to the admission room, you're just desperate for help. But before anyone even looks at you, a clerk slides a clipboard across the counter.
The dreaded clipboard.
Exactly. And it's got this form, conditions of admission. And you don't read it. I mean, who would? You just sign it because you need treatment. Now.
And that scene, that very moment, is where our entire story begins. That scribbled signature sparked a legal fight that completely changed the relationship between a patient and a hospital.
We are doing a deep dive today into the landmark case, Tunkl v. Regents of the University of California. And really, this isn't just about one person, Hugo Tunkl. It's a story about power.
It is. It's about necessity, and it's about this massive collision between two huge legal ideas. Freedom of contract on one side and public policy on the other. You know, the idea that you and I can agree to anything we want versus the law stepping in and saying, no, not this time. This agreement is bad for the public.
So let's get specific. The whole case hinges on one clause in Hugo Tunkl's paperwork. Condition number 6. And it basically said the patient releases the hospital from liability for any negligent acts of its employees.
In other words, if our doctors mess up and hurt you, you can't sue us.
It's a get-out-of-jail-free card.
That's what the hospital argued. They said, hey, you signed it, you agree to the terms.
Which brings us to the big question for today. Can a hospital, even a charitable one, actually do that? Can they make you sign away your right to sue for negligence just to get in the door?
That is the question. And to answer it, we're going to follow the court's own path. We'll look at the law, California Civil Code Section 1668, and then we are going to dissect the famous 6-factor test the court created to figure out when a contract involves the public interest.
Okay, so let's start with that baseline law. Before we even get to the case, is it generally illegal for two people to agree that one won't be liable for a screw-up?
Generally, no. In the private world, parties shift risk around all the time. If two businesses are making a deal, they can absolutely agree to hold each other harmless for ordinary negligence. It's just part of commerce.
But there's a line.
There is. California Civil Code Section 1668 draws a very hard line.
And what does it say exactly?
It says all contracts which have for their object, directly or indirectly, to exempt anyone from responsibility for his own fraud or willful injury, or violation of law, whether willful or negligent, are against the policy of the law.
Okay, so fraud and, intentionally hurting someone are out. That makes sense. But it also says violation of law, whether negligent. Negligence is a violation of law. So does that mean all waivers are illegal?
That's the tension, right? If you read it literally, you could argue it bans every single liability waiver. But the courts knew that would cause huge problems for the economy.
Right.
So the judicial interpretation, which is what Tunkl really solidifies, is that these waivers or exculpatory provisions are prohibited only if the transaction involves the public interest.
The public interest. That sounds broad. A little vague, maybe.
The court admitted it's a volatile concept, but in this case, they decided to create a clear framework, a test, to figure it out once and for all.
And that framework gets tested in the main event, the case itself. Tunkl v. Regents of the University of California.
The perfect testing ground.
Okay, let's analyze Tunkl v. Regents. First, what are the legally dispositive facts?
All right, so the plaintiff is Hugo Tunkl. The defendant is the Regents of the University of California who run the UCLA Medical Center. And it's important that this was a nonprofit charitable research hospital.
Okay.
Tunkl is admitted. He's handed the conditions of admission form. Condition number 6 in that form releases the hospital from liability for employee negligence, as long as the hospital was careful in selecting those employees.
And Tunkl's side made a specific move on that point, didn't they? About the hiring.
Yes, and this is so important for the legal question. The plaintiff stipulated, he formally agreed in court, that the hospital did use due care in selecting its doctors.
Why on earth would he agree to that?
To sharpen the issue. By taking the hospital's hiring practices off the table, he forced the court to focus on one single question. Can the hospital waive liability for a doctor's negligence in practice, even if they hired carefully?
Smart. So what happened at the first trial?
The trial court jury sided with the hospital. They said the release was valid, so Tunkl appealed.
And what was the core legal issue on appeal?
The question was crystal clear. Is an exculpatory clause in a hospital admission contract invalid under Civil Code Section 1668 because the transaction affects the public interest?
So what rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements for us.
The court held that such a clause is invalid if the transaction has characteristics of the public interest. And to figure that out, they created what we now call the Tunkl factors. It's a 6-element test.
Okay, what are they?
1. The business is a type suitable for public regulation. 2. The party performs a service of great importance, a practical necessity. 3. The party holds itself out as willing to serve the public.
Well,
4. The party has a decisive advantage in bargaining strength. 5. It uses a standardized adhesion contract, take it or leave it, with no option to pay more for protection. And 6. The person is placed under the seller's control, subject to their carelessness.
that's a comprehensive list.
Hmm.
Okay, now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element, suitability for public regulation?
Right. So the sub-issue there is just, does the government oversee this type of business? And the court looked at the Health and Safety Code. There were pages and pages of laws regulating hospitals.
So that was an easy one.
And very easy one. The court said, yes, this element is clearly met.
Understood. Now what about the second element, service of great importance?
Here the question is this a necessity or a luxury? And the court said it's hardly open to question. A hospital isn't like a movie theater or a country club. In our society, medical care is a fundamental necessity for health and life.
So another check mark.
Exactly. Element 2 met.
Now the third element is interesting, willingness to serve. UCLA argued they were a selective research hospital. They didn't take just anybody. Does that mean they weren't serving the public?
That was their big argument on this point. But the court's analysis was, are you open to the public generally, or are you a totally private club? The court said, look, even though you're selective based on research needs, you're still open to any member of the public who qualifies medically.
So you don't need a special invitation.
Precisely. It's not a private affair. So the court found that this element was also met.
Okay, so what about the fourth element, bargaining strength?
This one is all about the power dynamic, and the court's language here is powerful. It said, the admission room has no bargaining table. A person in physical distress can't shop around. They can't negotiate terms. The hospital holds all the cards, all the leverage.
A decisive advantage, as the court put it.
That's the phrase. So element 4 was met.
No bargaining table. I like that. Now the fifth element, adhesion contract.
Yeah, so this is about the contract itself. Was it a negotiation or just a standard form? It was obviously a standard take it or leave it document. But the key thing the court pointed out was that there was no way for Tunkl to pay a reasonable fee to opt out of the waiver.
He couldn't buy protection.
He couldn't. It was compulsory. So because of that, element 5 was met.
And finally, the sixth element, control and risk.
This is about the physical reality of what happens. When you're admitted to a hospital, you place yourself completely under their control. You might be unconscious, sedated. You are totally vulnerable to their carelessness.
You've surrendered all control.
You have. The risk is all on you, and the control is all with them. So the court concluded this final element was also met.
So after analyzing all the elements, what was the court's final conclusion?
The court found that the contract between the hospital and the patient hit every single one of the 6 characteristics. It was a clean sweep. Therefore, the transaction definitely affects the public interest, which makes the liability waiver invalid under Civil Code Section 1668.
So the trial court's decision was reversed.
Completely reversed. The court said you cannot shift the risk of your own negligence onto the weak bargainer.
I want to circle back to that idea of the weak bargainer. The bargaining power. Why does the law care so much about that here? I mean, I have no bargaining power with my cell phone company, but those contracts are still valid.
That is a fantastic question. To really get why this is different, let's just paint that visceral picture the court was imagining with the admission room.
Okay, let's do it.
Imagine the patient. They are in agony. Maybe they think they're having a heart attack. They are terrified. And across the counter is the hospital, the seller holding the keys to their survival. The patient, the buyer, can't shop around. They are desperate.
Yeah, you're not checking Google reviews at that point.
No. And at that exact moment, the hospital says, sign away your right to sue us or we won't treat you.
That isn't a contract. That's coercion.
It's exactly the point. The court says this is a decisive advantage. The patient isn't voluntarily agreeing to anything. They are being stripped of their autonomy by pure necessity. The law refuses to enforce that.
It makes perfect sense when you put it that way. It's not a real choice.
It's no choice at all. And public policy says the risk of negligence has to stay with the person or institution that is being negligent, not the victim.
Okay, this has been incredibly clear. But for anyone listening who needs to use this, maybe on an exam, can we synthesize it? Give us a diagnostic checklist.
Absolutely. We can call it the Tunkl Public Interest Checklist. When you see a liability waiver, you run it through these steps.
Okay, step one.
Step 1, check the statute. Is there a law like Civil Code 1668? And remember, you can never, ever waive liability for things like fraud or willful intentional harm.
Got it. Step two.
Step 2, apply the public interest filter. This is the 6-point diagnostic we just went through. Just ask the questions. Is it regulated? Is it a necessity? Is it open to the public? Is there a power imbalance?
Is it an adhesion contract with no buyout? And is the buyer under the seller's control?
Exactly. You just run down that list.
And step 3 is the outcome.
Step 3, the result. If you're answering yes to most or all of those questions, then that waiver, that exculpatory clause, is void. It's against public policy. The risk stays with the actor.
That's a fantastic tool.
Yeah.
It turns this big abstract idea into a simple, actionable test.
That's the goal. It reminds you that the law isn't just about what's written on a page, it's about the reality of the situation between the people involved.
Well, that brings us to the end of our deep dive into Tunkl. It really is amazing how one person signing a form in 1956 created a shield that protects millions of patients to this day.
It is. And if there's one final thought, it's that the law, when it's working right, refuses to let powerful institutions use legal technicalities to escape their basic responsibilities to the public.
A powerful thought to end on. Thanks for listening, and we'll catch you on the next deep dive.